Good day to you and welcome to another Paddocks Club video tutorial. Today I'm going to pick up on a comment made by Mark Bouchard in the discussion forum. He said, I thought I understood how exclusive use areas could be created until I read an article written by two attorneys. I didn't know that developers can register exclusive use areas as units. Is this correct? Now, the article he refers to is by Chantal Gladwin and Gabriel D'Amato of Schindler Attorneys, and it appeared in the bizcommunity.com area on the 27th of August 2014, that's last Wednesday. It was headed exclusive use areas should not attract municipal charges. I, as a general rule, don't comment on other attorneys' articles on sectional title, but in this case, this thing is so misleading and so wrong in important ways that I feel that I have to. It starts off by saying there are three ways in which exclusive use areas in sectional title schemes can be created, and it makes then the argument that they should all be treated in the same manner by the city of Johannesburg. None of them should be rated, they say, or otherwise attract any municipal charges at all. They start off by referring to exclusive use areas and saying that they're essentially areas of a sectional title scheme that are reserved for the exclusive use of a particular owner. That is correct, but it denies an important point which it is clear they don't understand, and that is that exclusive use rights can only be given in respect of areas of common property. A section is not an exclusive use area. They say that these areas can be created in one of three ways. The first is where the developer registers exclusive use areas. These can be transferred from one person to another by registration of a notarial deed of cession, they say. Well, clearly they're referring to Section 27 rights, and they are roughly right, but not quite, because either the developer or the body corporate can create such exclusive use rights. The second way they correctly describe, that's a Section 27A right, and here they say it can be created in terms of rules by either the developer or the body corporate. It's quite correct. The third way they say in which these areas can be created is where the developer registers certain areas as units in the scheme for the sole use of certain owners. These kinds of exclusive use areas, they say, need to be transferred in the deeds office. Well, here they are wrong. These are not exclusive use areas nor exclusive use rights. They're separate sections, and unless special arrangements are made to tie them to primary sections, they can be held separately. They then end up that part of their argument by saying there's no difference. For all intents and purposes, there's no difference in the types of rights that accrue to the owners or to the body corporate in respect of the three different ways in which exclusive use areas are registered. Now, this is just wrong and misleading. There are three ways you can cater for parking bays that are situated inside the building of a scheme. They can either be Section 27 exclusive use areas, they can be Section 27A exclusive use areas, or they can be sections. But there are only two types of exclusive use rights, under Section 27 and Section 27A, and you're always dealing with special rights that are held by one or more owners in respect of an area of common property. Parking bays that are sections are fundamentally different to those that are not sections, but are part of the common property and are subject to exclusive use rights. Sections have participation quotas on which levies are calculated, whereas people who hold rights to exclusive use areas pay on an entirely different basis. Sections and exclusive use areas are subject to entirely different maintenance obligations in terms of both the Act and the prescribed management rules. The argument that units where the section is a parking bay should be treated in the same way as parking bays that are exclusive use rights ignores the fact that parking bay sections are often owned by persons who don't own an apartment, an office, or a shop section. And in these cases, they must be treated separately and they must be separately rated. Thank you for joining me, and if you have any questions, let's deal with them in the discussion forum.